Hi guys, welcome back to Battle Pitola. This is Mujola Oluwa and I'm super thrilled to be here once again. Today we want to talk about a very important aspect of law, especially intellectual property law. Long time no IP, we've talked about IP a lot on this channel in time past, but I doubt if we've done a video on IP this year. So this is that video. If you recall, if you've been on this channel for as long as we've been here, about 3 years ago, we talked about copyright, we talked about fair use, related rights, and all of that. So today we want to talk about another aspect of intellectual property law that is connected to copyrights and probably a few other rights. We want to talk about public domain. Public domain. I'll tell you why I decided to talk about this. I was watching a video on YouTube recently. I've fallen in love with old videos, or I've been watching a bunch of old videos on YouTube, videos that date as far back as 1940s, 1950s, and that. So I watched this video, charade, and then there's a comment under that video that said that video went into public domain immediately it was made. So I was wondering what could have happened, so I decided let's talk about public domain. If you have ever taken a copyright law course, or if you're familiar with copyright, public domain is a part of it, so you probably know a few things about it. But in this video we'll talk about everything there is to be said, or that you need to know, the basics that you need to know about the concept of public domain. So please like the video when you've seen it. Please leave comments in the comment section. Let's continue the conversation, and by all means share the video and subscribe if you haven't subscribed. Thank you very much. Please always check the description box. That is where we have very important information, and if we want to make maybe an adjustment or put additional information out about something we've talked about on the channel, we will definitely put it in the description box. So please always check the description box. What is public domain? Public domain is that realm, so to speak, that intellectual property protected or copyright protected works move into after a certain period and are based upon certain criteria. So you know that copyright protects literary and artistic works, that covers musical works, photographic works, expressions of creativity. Once expressed, they are protected by copyright. They were not always automatically protected, but after a while they became automatically protected. We'll touch on that as well as we go on. As of today in Nigeria, in the world generally, copyright, artistic or creative expressions are automatically protected. Then you can go a step further by registering them. We've talked about that in the video on copyrights. Please watch that video. We'll leave a link to it in the description box. As a matter of fact, there's a whole playlist on intellectual property on the channel. I've brought an intellectual property law expert before who talked to us extensively about copyrights and trademarks. So watch those videos. So automatic protection came with the Berne Convention, of course. So your works are protected as soon as they've been expressed, as soon as they've moved from the realm of ideas or thoughts to tangible expressions. Now they are protected and they belong to you for the duration of your lifetime and for a certain period after your demise, or after the demise of the creator or the expressor of the creativity. Now once that period ends, what we have is that they move into what is known as the public domain, and that means that you no longer have rights over them, you no longer own them. It is now owned by the general public, so anyone can use, explore or exploit them as they see fit. So that is what public domain really means. You'd recall that when we talked about copyright, we made a note of the fact that copyright gives the owner or the expresser or the inventor, not inventor now because that would be moving to trademarks and patents. Copyright essentially, gives the right holder, yes, the right holder, the right to license or permit the usage of that work. So when the work moves into public domain, what it now means is that anyone that wants to use it does not need to get your license anymore. It doesn't mean that maybe they will remove your name from it or they will change the ownership. Yes, the ownership changes, but not that they will dissociate it from you. It just means that people no longer have to take your permission before they use or exploit that work, because it has now moved into public domain. Works can move into public domain by various means, and we'll talk about 4 or 5 of them. The first is that the copyright expires. Copyright can expire, so it is not a right that renews in perpetuity. Generally, copyright expires after the death of the right holder, but not just after the death. Different laws provide for the years of expiration, but generally the Berne Convention, which we'll talk about later in this video more extensively, covers, a whole lot of jurisdictions, and many jurisdictions have subscribed to that convention. So there's a stipulation under that convention for 50 years. So the validity of copyright is 50 years after the death of the author. In some laws, if you go to the US, to Nigeria, in some other countries, it is 70 years after the death of the author. So if you've written a book, for instance, in the year that you die, we count 70 years after December 31st of that year that you die. And then on December 31st of the 70th anniversary of your death as an author or a creator, it's not limited to written work, the copyright expires, which means that people can now use it. The general public can now use it without seeking your permission or taking a license. That's essentially what it means. Under the Berne Convention is 50 years. In Nigeria, if you check section 19 of the Copyright Act 2022, it provides for 70 years as well. That means that 70 years after the death of the author or the creator, the work moves into public domain. What works have moved into public domain that you can think of off the top of your head? The works of William Shakespeare, for instance, are in public domain because it's been hundreds of years since Shakespeare died. He died in 1616. As such, his works have moved into public domain for ages, so anyone can use them. And that is why you see many adaptations, many reworkings, rewritings, replays, reuses, and adjustments or exploitations of William Shakespeare's work, even those who do not need permission. So that's what it means. The works of Charles Dickens, Mark Twain, all those people have died, and it's been over 50, over 70 years since they died. So their works have moved into public domain. They can be exploited without permission. Also, some movies have moved into public domain. If you there's a video that I was watching also on YouTube. It's called Father's Little Dividend. It is also a film that has moved into public domain. You could Google these things. You could find a list of movies, films that have gone into public domain. There are songs that have gone into public domain. Last year, December 31st, 2023, Steamboat Willie's version of Mickey Mouse moved into public domain. That just means that it's no longer protected. It doesn't mean that the owner is no longer the owner, or the author is no longer the author, or the writer is no longer the writer, or the producer is no longer the producer. It just means that now anyone can use those works without taking permission or license. So a work can move into public domain by the expiration of copyright. That's the first method or means. The second one is non-renewal of the copyright. Copyrights can be subject to renewal in some instances. Before we move to the second means, it's important to also note that copyright expires on the 31st of December of the year in which it is to expire. Always, no matter when, what time of year the author died, it expires on the 31st of December. Also, in some other instances, there are some means of expiration that are beyond what the 70 years or the 50 years. For instance, in the United States, works that were made in 1923 and all, especially works made before 1924, all expired in 2019. So if there's any work that was created before 1924, protected by copyright, they expired in 2019. There can be some exceptions to this rule, but we're just talking about the general rule. And then when people subscribe when jurisdictions began to subscribe to the Berne Convention, it provided for 50 years after the death of the author. Now, if there are more than one author of a work or more than one creator, it expires on the anniversary of the death of the last surviving author. So if there are 5 authors now, it doesn't mean that once one has died 70 years after or 50 years after. No, it means that when the 5 of them have died, so if they are dying in different periods, when the last person has died, that's when you begin to count the 70 or the 50 years or the number of years that your jurisdiction subscribed to. Very important to check your copyright law in your own jurisdiction, and then to advise yourself by the Berne Convention if your country is a party to that convention. So 70 years or 50 years after the death of the last surviving author. Now, the second means is non-renewal of copyright. So if copyright is subject to renewal in a certain jurisdiction and it is not renewed at the appropriate time, it just moves into public domain automatically. So if maybe in your jurisdiction it says that, okay, when you create a work within this year and that year, there were some works in the United States that were created between 1923 and 1964 that were by law supposed to be renewed on the 28th anniversary of the work. Once they were not renewed, they moved into public domain. So if there's such a law binding, your copyright in your jurisdiction and the renewal is not carried out, it automatically moves into public domain. General jurisprudence or the legal systems are moving away from that because of the Berne Convention now and the automatic protection that comes with the Berne Convention. But essentially, it's important for you to make all necessary findings and clarifications in all the jurisdictions where your work is created, is going to be exploited or used or sold or hosted, to be certain that it is not subject to renewal. So if it is subject to renewal and you do not renew, it moves into public domain. That's the second means. The third means is works that are dedicated to the public domain by the copyright author. There are some works that may be dedicated at inception to the public domain. So if the author puts a dedication on the work and says, oh, this work is dedicated to the public domain, free for use, it is not protected by copyright laws, and so it is in public domain. Creative Commons is a not-for-profit organization that releases or hosts works that are free for use by the public, the general public, for educational purposes. Mostly works under this Creative Commons license are in public domain and they can be used without permission or licensing. That's the third means. The fourth means are works that are unprotected by copyrights ordinarily, such as keywords, phrases, catchphrases, slogans, with the exception of advertising slogans that can be trademarked. But works that cannot be protected by copyright ordinarily move into or are already in public domain. Ideas, for instance, theories, for instance, are not protected by copyright laws, and so they are in public domain, free for use by all and sundry. If you have come up with a catchphrase or with a peculiar phrase or with a theory or with an idea, it is important for you to explore the option of registering it or bringing it under copyright protection formally to be certain that it is protected. So because generally theories, ideas, thoughts, words, catchphrases, maybe idioms, slogans are not protected by copyright. So for instance, if someone is fond of saying a certain thing, maybe an honest personality is fond of making an idiom, for instance, that has become so associated with them, it does not automatically confer protection just because they say it and everyone knows that they say it. Idioms are not protected by copyright ordinarily. But if you want to explore protection, you could go for a trademark just to be certain. If it's rejected, then you know that you cannot. We talked about this channel, how Kanye West tried to trademark the phrase or the concept or the term Sunday school. Was it Sunday school? Something related to church. He wanted to trademark it and it was rejected by the trademark office when they said that, you know, it was a commonly used term that had been in existence before it became synonymous to or known with Kanye West, and so he could not trademark it because it's in public domain and it's for general use. So those are the means. So those are the means by which a work can come into public domain and is not protected by copyright laws. Also, works that are made by government officials may not enjoy copyright protection. You know, the copyright may not reside in the government official that made them in the course of his duty. So it's important to just be sure, to be certain. So let's talk about Charade. Charade is a movie that features Audrey Hepburn and some other A-list actors. So it's a very interesting movie. It talks about a widow, you know, her husband died, and apparently he had some CIA jewels or money or gold with him, valuable CIA stuff with him, which he had converted, you know, in a moment of temptation. But you know, it was an operation with about 3 or 4 other men, and so when he died, they came after his widow thinking that he had passed the wealth to her and they wanted to get it. And then there was, you know, another CIA government official who also wanted to retrieve the valuable for the government. So it was like a comedy of errors, but it's a very interesting movie if you want to see it. It was released in 1963 and it entered into public domain immediately. Although if you look it up online, if you make some research, you will find that there has been some moves to correct this issue. But what really happened then was that the producers or the makers failed to insert the appropriate copyright notice, and by law then, when you produce a literary or an artistic or a musical work like that, you have to put a copyright notice. Copyright notices include 3 things. It must contain copyright, the word copyright, or C in a circle. That's the copyright signature, C in a circle. It must contain that. It must contain the year of first production or first release. Then it must also contain the name of the copyright holder or the entity claiming the copyright. So those 3 things make up a copyright notice back then. So because when it was released in 1963, the makers failed to insert the C, the copyright, it went straight into public domain, so it could be exploited by anyone for free without licensing or permission. There has been steps made to remedy that, and some movies had to be, when the copyright expired too, some movies had to be remade, some movies had to be, you know, reimagined. You know, there are different ways to remedy the loss of copyright, but essentially what we want to learn from Charade is that because it failed to come with a copyright notice, it went into public domain. That is no longer the situation now. Now, copyrighted works under the Berne Convention enjoy automatic protection, and of course for the number of years after the death of the copyright holder. Very interesting, you'd say. Another important thing to note is that a collection of works that are already in public domain may enjoy copyright protection. Remember, we said that works that are moved to public domain are no longer require a license or permission from the creator. Now, if someone now brings together a collection of those works, or readapts or remakes or reimagines the work into another substantial version, say maybe a collection of Shakespeare stories by Mujola Oluwa Living Stones now, and maybe I've rewritten them, I've reimagined the stories, or I've exploited it, Shakespeare's original stories, the way I see fit, and put it in a book, in a collection. That book, that collection is copyright protected, and I am the copyright holder. So because the base of the work is a work that, or value that is already in public domain, does not automatically mean that anything that is built on it does not enjoy copyright protection. For instance, if a movie maker now makes a movie on the basis of Much Ado About Nothing, which is what Shakespeare wrote, Much Ado About Nothing. So if someone makes a movie on it, Much Ado About Nothing is no longer copyright protected because it is the story of Shakespeare, written by William Shakespeare, and it's already in public domain. But that movie made in 2024 is copyright protected, and the maker is the copyright holder. So we must differentiate between these two things. Very important. Now let's talk about the Berne Convention of 1886. The Berne Convention. Berne is a place in Switzerland. You know, there are so many treaties, so many pacts, so many conventions that come from that side of the world. One day I'm going to do a tour. I'm going to be visiting all those places. Oh, this is where this treaty was made. This is where that convention was made. You recall the Rome Statute too that gave birth to the ICC, the UN Charter, all those conventions and treaties. So we have the Berne Convention of 1886. It is the international body of law that confers protection, copyright protection on literary and artistic works or creations or expressions for contracting states, for works that originate from contracting states. So essentially, if your country is a signatory to the Berne Convention, your country is a contracting state. So every work that originates from your country will enjoy protection under the Berne Convention. Berne Convention provides for the minimum protection that can be enjoyed by literary and artistic works. Also, there are three crucial things that the Berne Convention introduced into copyright protection space. The first one is it created what is known as national treatment. That means that your work will be accorded the same level of protection that is accorded literary and artistic works in a contracting state. So if I am from Nigeria and you are from Ghana, and Ghana and Nigeria are both signatories or contracting states to the Berne Convention of 1886, when I create my work in Nigeria, if it gets to Ghana, it will be protected under Ghana's copyright law automatically. I would not need to, re-register or reassert my copyright because we are both signatories to the Berne Convention. What works that are created in Ghana enjoys, my work will enjoy when it is in Ghana or when it is under the Ghanaian jurisdiction. So national treatment. The second one is automatic protection, which I mentioned earlier. That means that if your country is a signatory to the Berne Convention, a contracting state, works created in your country or in all contracting states enjoy automatic protection. So there's no need to register the work at first instance. You may register it like we talked about in the copyright video about 3 years ago, just to clear all doubts and to have something tangible to assert your right with, especially if there's a controversy around it. But in the absence of that, your work, once created or expressed, enjoys automatic protection. That's one other thing that the Berne Convention brought. The third thing is independent protection. That means that regardless of the protection that is available to my work in my country, Nigeria, once it moves to Ghana, it must be protected under the Ghanaian law and by the Berne Convention being implemented in Ghana. The only exceptions is that if, for example, there's protection in my country, but it is for a shorter period, then, or the one under the Berne Convention is for a shorter period, then respect must be had to that. For instance, if my work is protected for 50 years in my country, when it moves to Ghana and it is 70 years in Ghana, it must be automatically protected regardless of the protection in my country. But where 70 will now exceed 50, then Ghana's law will defer to 50 or defer to 50. 50 is what the Berne Convention also provides. So independent protection, national treatment, and automatic protection. Those are the three most important things that the Berne Convention of 1886 introduced into the copyright protection space. Protection is not just 50 years flat. Under the Berne Convention, there's 50 years for literary and artistic works. There's 25 years for, that's 50 years after the death of the author or the last surviving author. There are different levels of protection for different types of works under the Berne Convention, but generally it provides for 50 years after the death of the author, for literary and artistic works. or 50 years after the death of the last surviving author, where there are multiple authors. For photographic works and applied arts, it provides for 25 years protection from the date that the work was first expressed or released. So that's for photographic works. For applied arts, so you could also look through the convention and through the laws of your various jurisdictions for the particular protection it gives to your type of work. We're just talking about the more common types of work in this video. Also, protection can differ from country to country, so you have to be most certain. For instance, George Bernard Shaw died in 1950. In the Canadian Copyright Act, protection is 50 years after the death of the author. But in the United States, it is 70 years after the death of the author. That means that George Bernard Shaw's works moved into the public domain by 2000 in Canada, but he had to wait for 20 years more. So 2020 before it could move into public domain in the United States. Very interesting, right? There are so many other interesting examples of disparity in movement into public domain of a copyrighted work, from jurisdiction to jurisdiction. So it's important for you to be certain that a work has actually moved. For works of people like Mark Twain, William Shakespeare, like we said earlier, it's been hundreds of years since their death, so their works need no arguments, no controversy about having moved into the public domain. Also, it's important, if there's a controversy about a work having moved into public domain, better to steer clear of it as someone who is creative or wants to explore or exploit that work. Better to steer clear of it or seek the appropriate copyright protection. When works lose their copyrights, they can be palliated. That is, if it's due to non-renewal now, they could seek remedies. There are remedies provided by law, maybe payment of a fine or doing of a certain thing, or reimagining the work in another format, to regain the copyright. So it's important for you not to just assume that, oh, this work has lost its copyright, I can use it freely. Very important to be very certain. What have we learned in this video? Public domain simply means that a work no longer enjoys copyright protection, and it can be due to several reasons. And from that point on, it becomes available to the general public to be used and exploited as they see fit. It's different from fair use, where the work is still protected, but you can use it to certain extents. So please watch all these videos and let's continue the conversation in the comment section. I will see you in my very next video. Don't forget to subscribe and bring a friend along to Bar Talk with Ola. To-dos.